The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. Our next case is Plantation Building of Wilmington, Inc. versus Town of Leland, and we'll hear from the appellant.
Thank you, Mr. Chief Justice, and may it please the court. My name is Stephen Carey, and I'm from the law firm of Parker, Poe, Adams, and Bernstein. And I'm here today on behalf of the defendant appellant, the Town of Leland. I'd like to reserve 5 minutes of my time for rebuttal, please. We're here on interlocutory appeal of the trial court's order granting class certification. And this appeal boils down to a single issue. May a trial court grant class certification after the plaintiff has sought and obtained summary judgment on the merits on its claims? And the answer to that question is no. The answer to that question is no, because it is unfair. It is unfair to absent class members, and it's unfair to class action defendants like the Town of Leland. Because the answer to that question is no, the trial court's order certifying a class here should be reversed and the class decertified. I'd like to start by...
Is it your position that the counsel at the time for the defendant did not concede to the timing of summary judgment first and then class certification, depending on how that went?
A sort of qualified yes, Your Honor. The counsel agreed that summary judgment, cross motions for summary judgment would be heard. And then if the matter were not resolved at summary judgment, class certification would be heard. But that didn't waive any right to later object to class certification on any grounds that could have been brought, because the issue of class certification was not ripe at any time prior to the motion for class certification being filed. A plaintiff is free to file its motion for summary judgment at any time 30 days after commencement of the action. That's in Rule 56A. It's free to do so at any time. And the trial court was free to resolve the summary judgment motions, which were the only motions pending before it at the time. You had cross motions for summary judgment between the plaintiff and the defendant. And I think that's a key piece of information to keep in mind here. Before class certification, before a motion for class certification and a certification order, the only parties to the case are the plaintiff, Plantation Building, and the defendant, the Town of Leland. And so the trial court was free to hear summary judgment, and plaintiff was free to move for summary judgment. I think that's a confusion that sort of runs through appellee's argument. Our contention is not that that was improper. The question is, what is the impact of that? And the impact of that has been clear as a matter of law in North Carolina for over 40 years, since at least 1979.
Mr. Carey, to follow up on the Chief Justice's question for a second, is there anything in the record prior to the date that the summary judgment hearing was held that suggested that your client would take the position that it is now taking with respect to the effect of the entry of an order granting partial summary judgment in favor of the plaintiff?
Justice Ervin, I suppose that the continuance order on which the plaintiff relies suggests that, because it says that summary judgment, cross motions for summary judgment will be heard. And then if the matter is not resolved at summary judgment, then it will move on to class certification. But this matter was resolved. But I would back up.
Is there anything that suggests that your client indicated that it would make the one-way intervention argument that it is now making at any time prior to the summary judgment hearing?
No, Your Honor. There's nothing in the record that suggests that, but it's because there's nothing that would not need to be raised. That issue is not yet ripe until a motion for class certification has been filed. So there's, if a plaintiff...
So your argument then is that even though your predecessor counsel, I understand you didn't do it, but your predecessor counsel agreed to a set of procedures that contemplated hearing summary judgment motions to be filed by both parties first, and then dealing with the class certification action later. That the agreement to that sort of procedure reserves your right implicitly to make a one-way intervention argument.
Yes, Your Honor, because the town didn't waive any rights or arguments that it could bring at the class certification stage, including
And I'll stop asking questions and let you get to your point in just a second, but at least I understood your brief to say that the only way that you could make such a waiver was if you intentionally, openly, and explicitly did so.
And Your Honor, that is what our briefs say, and that does appear to be, some cases have held, say that, for example, the Third Circuit in the Katz case did hold that it could be waived when it's expressed. I do wonder, it brings me to the absent class members and their due process rights. I'm not sure, and I don't believe that a defendant can waive the procedure because of the harm it would do to absent class members.
Well, and I guess my next question becomes, what standing does the defendant have to raise arguments concerning fairness to absent class members?
Right, Your Honor. That was addressed by the United States Supreme Court in Phillips Petroleum versus Stutz, and the same question was raised, and the Supreme Court said that the class action defendant has standing to raise the due process interests of absent class members because of the defendant's interest in ensuring that the class is properly formed, and that the defendant is properly bound to a judgment one way or another against the class. And that the concern would be that an absent class member could bring a second suit and argue that it's not bound due to some error in the procedure, some lack of due process. And so the Supreme Court, the U.S. Supreme Court, held in that circumstance, which is the circumstance here, that the defendant has the authority to raise the due process interests of the absent class members.
Isn't there a certain level of irony or perhaps even lack of applicability of that case, however, if on one hand, the defendant is saying that a class should not be certified, but yet on the other hand, say that the class members or potential class members should have their rights protected by this would-be defendant in a class to protect the interests of the would-be plaintiffs?
Well, Your Honor, the issue is the defendant's interest in making sure that the class has been properly formed. And I think there's a fundamental problem with the formation of this class. And the fundamental problem is that due process was not served to the absent class members. Absent class members were not provided with notice and an opportunity to come before the court, intervene, or at least oversee the conduct of the litigation, the merits of their claims by the plaintiff. And
wouldn't potential class members have their own legal methods by which to protect their own interests? Should there be a class certified or not certified, as the case might be, without having the town to take it upon itself to try to protect those would-be plaintiffs' interests?
Well, Your Honor, but that's the problem. Those absent class members don't even know the litigation is being conducted. And that's why it's so important that class certification come early in the litigation. That's what this court held in Crow. And that it's certainly that class certification and notice to the class certainly come before the merits are determined. And that was established by the Court of Appeals in English, which this court cited with approval.
Well, I know the Chief Justice and Justice, I'm sorry, Justice Hudson.
No, I'm sorry. I thought you were done. Go ahead.
I've just got one more, if I may. Thank you, Justice Hudson. Along the same line with the Chief Justice's question and Justice Irvin's question concerning the effect upon one-way intervention, doesn't the position that your client took at the trial level concerning the stipulation to have the agreement that the summary judgment motions would be heard prior to the class certification motion, doesn't that in effect have your predecessor counsel to presuppose that the matter was going to go a certain way in terms of the dispositive motions and then come back and try to impose this one-way intervention aspect?
Yes, Your Honor, I guess a handful of responses to that. First, as I said earlier, the time to raise the one-way intervention issue is at the very earliest when there's a motion for class certification pending. There was no motion for class certification pending. That distinguishes this case from virtually every other case I've seen.
Nor was there one for one-way intervention because of the stipulation by the council.
Well, I suppose I don't entirely agree to the idea that it was a stipulation, or at least as to the meaning of the stipulation.
Well, let's call it an agreement then that the competing summary judgment motions would be determined prior to the class certification motion. There was agreement on that from your predecessor council.
But Your Honor, let's switch that around. Say say Leland won at summary judgment. I don't think there'd be any question that Leland couldn't turn and then say, all right, let's go ahead and bring the motion for class certification, and let's bind all these absent class members to the negative decision that they had no notice of and no opportunity to be present for. The same has got to be true. The flip side of the coin has to be true for the plaintiff. The plaintiff cannot bind those absent class members before they've been provided notice and opportunity to be heard. So the result.
Let's help me with that a little bit, Mr. Carey. It seems to me that, for example, let's just assume that we don't even have a class allocation here at all. Let's say that the plaintiff had brought an individual suit for its $121 some odd thousand in impact fees against the town, prevailed, the town appealed, the court upheld the judgment. Wouldn't that effectively determine how any subsequent case would be decided as well?
Well, I think that raises the issue of sort of non-mutual claim preclusion, right?
I'm not talking about claim preclusion. I'm just saying, in effect, that let's say the party B that comes in and files suit against the town. You've already got an appellate decision on point indicating how it comes out.
But Your Honor, that is, sorry, I don't mean to quibble, but that is offensive non-mutual claim preclusion. You're saying this new plaintiff, can use the decision against another plaintiff against the same defendant as of binding effect, and that Leland couldn't present different arguments vis-a-vis that plaintiff, if I understand the hypothetical correctly.
I'm talking about if we've got two totally separate cases, one brought after the other, and you've got an appellate decision one way or the other in the first one. As a practical matter, that's going to be determinative of the second case, isn't it?
Well, there could be defenses that the town has against the new plaintiff that it didn't have against the old one. I mean, it's hard to know how binding that appellate decision is going to be on the other plaintiff. And so then the question is, can you use that decision to bind the defendant through some sort of preclusion? Again, I don't mean to quibble, but it seems to me that there could be arguments that the defendant has that apply to this new plaintiff that don't apply in the second action.
On the flip side, though, if you had prevailed, then you would have some ability to say, in effect, our success in this case limits the ability of future plaintiffs to prevail, wouldn't you?
But yeah, then that's the choice a defendant makes. A choice because I don't think that the defendant would have a preclusive argument. It would have at best stare decisis. It would have,
and I guess that goes back to the concern of my further question. In the event that a defendant, for whatever reason, elects to proceed in that fashion as a matter of strategy, why is the defendant at a later time with different counsel allowed to change course and say that not only we want to adopt a different approach, but that it was error for the court to adopt the first?
Because the trial court, we're not saying it was error for the court to adopt the first one. We're saying it was error for the court to certify a class. The trial
I understand that, but if you view the actions taken by your former counsel as agreeing to a course of proceeding in which there were potential benefits to both sides, why does the defendant later get to say, well, the assumption that everybody was operating on at the time we used these procedures is illegal?
Well, because I think not only does it presuppose that the defendant was supposed to raise the issue earlier without a motion to object to, without a motion for class certification to say, Your Honor.
There was a class allegation in the complaint, wasn't it?
Yes, Your Honor. But then the plaintiff, on its own accord, voluntarily and without any obligation to do so, moved for summary judgment on its own claim.
As did the defendant, didn't
But
it?
the defendant is under Reap v. Beck and cases across the country. The defendant is definitely free to do that because there is no due process concern there. Because a favorable decision for the defendant on a dispositive motion does not bind the absent class members, and in addition, it serves economy and efficiency goals of Rule 23 to resolve frivolous claims. So a defendant's motion and a plaintiff's motion are very different things. But I think I do agree, a plaintiff is free to make the decision in its own calculation that I'm going to try my luck on my own claim, and if I win at summary judgment, I suppose I'm precluded from later moving for class certification. The plaintiff should know that because of English. The plaintiff should know that because of Crow. The plaintiff should know that because there's a requirement under Rule 23 and this court's precedents to bring class certification as early as possible in the litigation. Waiting until after.
Let me ask this question I've been wanting to ask for a bit. You've referred a number of times to not binding on absent class members, but as I understand, what occurred here is that your prior counsel agreed to a consent order setting the procedure where the class motion would be heard after the summary judgment motions. And so my question is, what effect do you contend that the consent order had on binding your client to that procedure?
Your Honor, so that was a consent order, an administrative order setting a new trial date. Every sentence that comes before it is the party's justification for why a trial date needed to be moved. The only binding aspect of that consent order is the new trial date. It was also a consent order signed by a trial court administrator as an administrative matter, moving the trial date. And so there was no scheduling order in this case. And we know that because in that order, the very order they rely on, it says that summary judgment is going to be heard in December. But summary judgment wasn't heard until March. But we can go through.
So are you saying, if I'm understanding you correctly, are you saying that or contending that that your prior counsel, by agreeing to and signing a consent order on the order of scheduling of motions, wasn't binding its client to that order, that it could back out if it wanted to?
No, Your Honor, that's not what I'm saying. I'm saying that it did not set dates certain for any motion to be brought. And I think the language is key. It says if this matter is not resolved at summary judgment, the parties will proceed to class certification. And this matter was resolved. It was resolved in Plantation Building's favor, with just a small sliver of a question of damages remaining. And I think one point I do want to make is that
You're not disputing that there was still issues yet to be resolved in the case, that the case was not over after the summary judgment hearing, was it?
The precise calculation of damages was all that remained, is what I would contend.
Counsel, do you dispute that there were ongoing discussions between plaintiff and defendant's counsel with regard to the class certification issue, including settlement discussions?
Yes, Your Honor, there were ongoing discussions at the time, including settlement discussions. And I think that Justice Newby points to one of the problems here. And one of the dangers of allowing this to proceed like this is that the plaintiff, it's clear from the record, the plaintiff was using the merits decision and the threat of moving for class certification as leverage for settlement.
But your client knew all along that this was filed as a class action and that the complaint itself envisioned seeking to recover all of the fees if the court were inclined to rule in favor of the plaintiff, not just of the named plaintiffs, but anyone else in the class.
Yes, Your Honor.
Contemplated in the complaint.
Yes, Your Honor, was in the complaint. But this shifts the burden on the defendant to make sure that the requirement that class certification be brought as soon as possible in the litigation so that the class becomes notice. It shifts that burden onto the defendant. Now it's the defendant's job to stop and say, class counsel, plaintiff, are you sure? Do you want to proceed this way? Are you positive? You know that you could have a problem if you get a merits judgment before class certification, and you know you owe a fiduciary obligation to those absent class members, and you know there's a concern about the due process rights of those absent class members. So maybe you want to stop and pause about that. That shifts an impossible burden on the defendant to police the strategy of the plaintiff, to requires them to urge them to bring class certification early when they're already under an obligation to do so. And so, and then,
or would another way to look at it be that it puts a burden on the defendant not to agree to the kind of process that was used here if it wishes to preserve a one-way intervention argument?
Well, I don't think so, because again, how can Leland object to the plaintiff's ability to seek summary judgment on its own behalf?
Well, I mean, but I guess where I'm having trouble with your argument, Mr. Carey, is that it does not look to me from reading the record as if the decision of the plaintiff to proceed with the summary judgment motion was taken in isolation. That instead, there were a series of decisions taken that included not just the filing of a partial summary judgment motion or even a summary judgment motion by the plaintiff, but also a cross motion by the defendant, with the agreement of the parties that, assuming the case was not resolved, and we've already talked about what that means, the class certification motion would follow. So it looks to me like it's appropriate to take all of that in context rather than to just look in isolation at the filing of the summary judgment motion by the plaintiffs, because it's not clear to me that the parties perceived it as anything other than a collection of procedures to be used in moving forward.
But Justice Ervin, it is the plaintiff's burden, not Leland's, to show that it meets the requirements of Rule 23. It is the plaintiff's burden, not Leland's, to mind its fiduciary obligations to absent class members. And it's plaintiff's burden, not Leland's, under this court's precedents, to bring its motion for class certification as early as possible in the litigation, delaying it until the effective end of the litigation, delaying it until after summary judgment. Under no contention could that be bringing that as early as possible in the litigation. We've never heard from the plaintiff, other than the devil made me do it, why it didn't bring its motion earlier. And this was sophisticated class counsel who know about their obligations to the absent class members, and they chose to go down this route. And it's not Leland's job to police that. They can secure summary judgment on behalf of their client. The absent class members get the benefit of the statute of limitations and can bring their own case.
Counsel, weren't both sides being strategic about all of this in terms of settlement negotiations going on, the potential for class certification, the posturing of motions, and as a result, it was left to the parties, once they made this agreement, to follow matters a certain way, that the trial court allowed that to take place in the trial court's discretion anyway under Reed versus Beck?
No, because that places, yes, both parties are responsible for their own strategy. And what will happen here is, if this is approved, that the defendant will be responsible for plaintiff's strategy. Defendant will have to police plaintiff's strategy and say, don't forget, you're supposed to bring your motion for class certification early. And are you sure you want to move for summary judgment right now? I mean, I think this case could be different if there were I think there would still be problems, but if there were a pending motion for class certification at the time of summary judgment, then you might have the exercise of discretion by a trial court. Then you might have a failure of Leland to address these issues. But when a plaintiff brings voluntarily on its own accord, when it is not under no obligation to do so, a motion for summary judgment on its own behalf on the merits, it puts the cart before the horse.
Pursuant to an agreement with the counsel on the other side that dispositive motions would not be heard, or rather would be heard prior to the class certification.
But that just follows from the fact that the plaintiff wants to bring its own motion for summary judgment. I mean, again, you're placing the burden on the defendant to say, are you sure? Is that really what you want to do? You might have a problem. And have you thought about the absent class members? Leland does not owe them a fiduciary duty. It's not its requirement to bring its motion for class certification early to make sure that the due process rights of the absent class members are met. It's the plaintiff's. And the plaintiff very much wants this case to be about what Leland did and not about what it did. And it decided under its own accord, when it was under no obligation to do so, to bring its motion for summary judgment before even moving for class certification. And in that scenario, the trial court's order certifying a class is incorrect as a matter of law and should be reversed and the class decertified. And I'd like to reserve the remainder of my time for rebuttal, if I may.
Thank you, counsel. We'll hear from the appellee.
Mr. Chief Justice, and may it please the court, my name is Mark Sigmund, and I represent the named plaintiff in this case and the 48 other class members who simply want to recoup the fees that Leland illegally extracted from them. There are some interesting legal issues in this case, but this court need not and should not reach any of them because the procedure followed in this case is exactly what the parties agreed to in the consent order. We are here today only because Leland hired new counsel, and that new counsel hatched a creative new legal theory. The problem for Leland is that it was way too late in the case to do that, and that theory ignores how this case was actually litigated. This case is actually pretty easy, and the court should affirm certification of the class. Let me begin with the consent order. I don't want to beat a dead horse or belabor anything, and I'm happy to answer any questions about that. But to me, the plain language of the consent order clearly allows exactly what happened here. Quote, if the matter is not resolved at summary judgment, then the matter will proceed to class certification. Leland's only argument to get out of that is to claim that this case was somehow resolved on summary judgment, but not concluded on summary judgment. Now, I read its definitions of those two terms, and they are exactly the same to my mind. And so I don't even understand what its argument is. But I'll tell you something else. When I got the reply brief, I went to the Merriam-Webster online dictionary that they cited, and I typed in the word resolved because I wanted to make sure that they cited it correctly. And they did. And then I noticed a little green button on the top right that said thesaurus. And I clicked on that button and I typed in the word resolved. And guess what the second listed synonym of the word resolved is? It's concluded. And so I don't think this court needs to cite a dictionary in this case because I think this is plain English. But if the court wants to, the court can cite the very authority cited by Leland, which says that resolved and concluded are synonyms. And Leland in its brief admits that this case was not concluded at summary judgment. And therefore, it admits the case was not resolved at summary judgment. And so this argument that they make, it's not based on the English language, but whatever it is, it fails. Second point about that, it occurred to me when I saw Leland's argument about the word resolved, that Leland itself maybe used that word in his briefing in this case. And so I looked at his brief, and guess what it wrote on page 12 of its opening brief to this court? Its opening brief to this court, Leland wrote this, quote, a second mediation was held on 8 June 2020, but the matter was not resolved. The matter was not resolved. That is the exact same language that's in the consent order. And what did Leland mean by that? It meant that because the parties did not settle the case at mediation, then the case didn't go away. The file wasn't closed. Other stuff remained to be done. The matter was not resolved. Likewise, here at summary judgment, the case didn't go away. The other stuff remained to be done. The matter was not resolved. And so if the dictionary that Leland cites isn't good enough for the court, then I think the court simply cite page 12 of Leland's own brief, which uses the exact same language in the consent order in the exact way that we, the plaintiffs, say it means, and directly contrary to what Leland now says it means. I think the court understood exactly what actually happened in this case, which is that Leland's original counsel agreed exactly what happened here, which is why after summary judgment, we served discovery going solely to class-based issues. Who are the class members, what are their damages? Leland responded to that without objection. Without objection. If Leland actually had a problem with that, it would have said something like, hey, class certification is off the table, but it never did that. Not only that, but even after that, over a course of more than a month, there were settlement discussions going on, all on a class-based issue. And Leland's counsel never said, not once did they say, hey, class certification is no longer on the table. And it didn't do that because that counsel had every idea that this case would go to class certification. It wasn't until Leland's latest counsel came in, but of course it was way too late for that. Moving on to the actual one-way intervention doctrine itself, our brief argued that the defendant can waive that in 3 different ways. First, they can waive it by agreeing to the scheduling of the motions. The 2 best cases for that are In re Forsman and Flo and Eddie versus Sirius. Both of those cases are directly on point. Both of those cases, Leland has no substantive reply to in its brief. Just check out its reply brief. There's no response there. And importantly, contrary to opposing counsel's argument about the fact that there was no pending motion for class certification here, that somehow makes a difference, that doesn't make a difference. Look at the Flo and Eddie case. There, the plaintiff, and only the plaintiff, moved for summary judgment, just like here. The court granted summary judgment, just like here. Then the plaintiff moved for class cert, just like here. The defendant objected on one-way intervention, just like here, and that court held this, quote, the court concludes that the rule does not bar certification because SiriusXM consented to Flo and Eddie's early summary judgment motion, thus waiving the protections of the one-way intervention rule. Case closed. That case is directly on point. Second, Leland, even aside from agreeing to the schedule, Leland waived the one-way intervention doctrine by filing its own motion for summary judgment. Its choice to do that. We cited several cases about that. The Kohler case in Pennsylvania 2019 held that because one-way intervention, quote, is for the protection of the defendant, it may be waived by a defendant who agrees to a pre-certification merits ruling. That's what happened here. The Reynolds case, 2010, it held that by the defendant moving for summary judgment, defendants, quote, have therefore implicitly waived any right they may have had to have class certification issues decided first. The Rhodes case, just like here, cross motions for summary judgment. The defendant's summary judgment was denied, then there was class certification. Frankly, Your Honor, the truth is that in the class action world, where my client is in here, most defendants, apparently other than Leland, know very well that if you move for summary judgment yourself, you can't then rely on one-way intervention. That's common knowledge. In the Reyes case, for example, there was actually a huge dispute about whether the defendant had moved for summary judgment. And the reason why there was that dispute was because everyone agreed, the plaintiff, the defendant, and the court, they all agreed that if the defendant had moved for summary judgment, then one-way intervention was off the table. But what happened there was the plaintiff moved, and the defendant, in responding to that, sort of seemed to make its own motion. And so there was this big dispute of, did the defendant move or not? Because if the defendant had moved, clearly one-way intervention was off the table. And so here, of course, there's no dispute about whether defendant moved. That's undisputed. It filed its own motion. And so if this case right now were in front of the Reyes court, it would be about a 1-paragraph opinion. It would just say, well, the defendant moved, one-way intervention is off the table.
Counsel, I know you said earlier at the outset that there was no need for this court to address the legal theories advanced by the defendant because of how matters proceeded pursuant to the consent agreement and what unfolded from that point. Does this court need to at all determine how, if in any way, Reed versus Beck applies, or does this court simply need to stay away from a discussion of that case because what the parties agreed to do through the consent agreement, in fact, was what was accomplished?
As the latter, Your Honor, this court does not need to wade into any of these issues. It does not need to even discuss one-way intervention. Maybe it's a fine doctrine for this court to adopt later, but now is not the case for that. No, Your Honor. The answer is that, if I were writing this opinion, I would cite the procedural history. I would cite the consent order, along with everything else that buttresses the clear history showing that Leland had agreed to this. And then I would say that, you can't complain based on this record, whether that's waiver, whether that's invited error, however you want to call it. And so, yeah, no. And the argument I'm making now is simply, if for some reason the court even gets past the consent order, why, even if the consent order did not exist at all, why class certification should be affirmed here. And it should be. We don't need the consent order. I mean, even if the consent order did not exist, because Leland filed its own motion for summary judgment, that's enough. And again, the fact that, that plaintiff also moved for summary judgment here, that's irrelevant. That's irrelevant even under federal law. The Berenson case that we cited, for example, there the defendant moved for summary judgment, but had summary judgment rendered against it. And the court held that it cannot then complain. And that's even more true in North Carolina under our Rule 56, which specifically allows for rulings for summary judgment against the moving party. And so even if only Leland had moved for summary judgment here, it would be the same result. In fact, frankly, my client didn't even really need to move for summary judgment here. The motions were mirror images of each other, the exact same arguments. If only Leland had moved, the court would have, almost certainly done the same thing and issued summary judgment against Leland, and we'd be in the exact same position here. And finally, the Leland waived its right under the one-way intervention doctrine by failing to object before the summary judgment ruling. So putting aside the consent order, putting aside the fact that Leland itself moved, it waived it by failing to raise it before summary judgment. We cited two cases about that, the Reyes case, 2018, and the A-League case, 2016. Both of those are directly on point. And Leland's only...
Mr. Sigmund, what do you make of Mr. Carey's argument that it's not Leland's obligation to protect you from the consequences, as he sees it, of your own client's decision to move for summary judgment?
I agree that it's not a defendant's obligation to consider my client's strategic obligations. But what's good for the goose is is good for the gander. It's not the plaintiff's obligation to protect the defendants from the consequences of its own choice, and that's what matters here. Let's be frank. If Leland had said at the very beginning of this case, "Hey, one-way intervention," if they'd refused to sign the consent order, if they had said, "You know what, we're not going to move for summary judgment because we think that's inappropriate," if any of these issues that they had now raised had actually been raised, this case would have been litigated very differently. We would have said to Leland, "Okay, well, I guess we'll move for class cert first, even though that doesn't really make any sense here. And even though you, Leland, are the one that proposed this." And so it would have been a different world. You can't just, you can't unwind this clock. And so, there was no strategic decision that the plaintiff made here that we're trying to escape from. It's Leland is the one that's trying to escape from its strategic decisions. Its decision to enter into the consent order, to file its own motion for summary judgment, not to object on one-way intervention grounds when we did, then to respond to the class discovery without objecting, then to negotiate for a month. This is all procedural gamesmanship by Leland here. And frankly, it's been very frustrating for my client's trial counsel to go through this case, in good faith for 2 years on a mutual understanding of what was going on. And then for all this to arise, on the 95th yard line.
If I can ask a question about our obligation here to review under an abuse of discretion standard, the trial court's class certification order, because don't our precedents suggest that the trial court has the discretion in a class situation to decide what ordering of motions it wishes to hear? It's true, we have not adopted the one-way intervention rule. So what can you say about whether it would be an abuse of discretion for the trial court to proceed the way they did in this case?
That's exactly right, Justice Earls. The standard of review is abuse of discretion. I don't think Leland noted that in its opening brief, but we certainly noted it in ours. That is the standard. I think that's, reading Leland's reply brief, I think that's undisputed now. And so that's a high burden, obviously. And so did the court here abuse its discretion in sequencing the motions like it did? It seems impossible to me to find that it did. And so, yes, that is. Now, to be fair to Leland, legal arguments under abuse of discretion are sometimes sort of considered de novo. And so, could this court consider, whether the one-way intervention doctrine itself applies? Could that arise to de novo? Possibly. But again, this case does not involve that doctrine. It should not involve that doctrine. And so ultimately, this is a case simply about abuse of discretion. And finishing up on the Reyes and A-League cases, both of those cases are directly on point. Both of those cases held that you cannot wait until after summary judgment to raise this issue. The defendant cannot. Leland has no response to those cases in his brief other than to say that those holdings were on motions for reconsideration, to which I respond, so what? I mean, the holding is the holding. The holding is, hey, defendant, you need to raise the one-way intervention before summary judgment is ruled upon if you're going to raise it. The fact that that holding was on reconsideration is irrelevant. I mean, the holding could have been on an appellate opinion. I mean, that wouldn't make a difference. Moving on very briefly to the due process rights of the absent class members. You know, that argument doesn't make any sense to me. And it makes no sense to me because the merits ruling here was obviously nothing but good for the absent class members. Leland has tried again and again to make up some harm here to the absent class members. But, you know, frankly, there simply isn't any. And not only that, but I would point out that, you know, I think that Leland has essentially admitted that the ruling here is nothing but good for the absent class members by raising the issue of one-way intervention. Because think about it, one-way intervention is based on this idea that it's unfair to allow class members a peek, a free look at a merits ruling, and then jump on the train only when they realize that the merits ruling is nothing but good for the class. Well, how can Leland then turn around and say, well, something over here was bad for the class? You know, you can argue one or the other. One-way intervention, absent class members' rights. You really can't argue both. It's nonsensical. The truth here, Your Honor, is that one-way intervention was at least implicated in this case. It was implicated because the merits ruling here is in fact nothing but good for the absent class members. The issue is simply that one-way intervention was waived here. But this argument about the rights of the absent class members is a complete red herring, and the court doesn't really need to say much about it other than the fact that everything here that happened was good for the absent class members. I would also note that the absent class members' rights here are the exact same as the absent class members' rights in all of the federal cases we cited where class certification followed summary judgment, whether that was plaintiff's motion or defendant's motion or cross motion. In all of those cases, and there was tons, and we cited them, there was class certification after summary judgment. So the defendants there had or the class members there had the same exact due process interests as the class members here. And that wasn't a problem. And so if this court were to buy Leland's argument here about that, it would not just essentially, but actually be contradicting the rationale of all of those courts, which is why the leading treatise that we cited recognizes that there's no problem here. Newberg section 712, quote, if a court rules on a dispositive motion prior to ruling on class certification and the plaintiff prevails, the class's interests have been safeguarded and the case may proceed to a certification decision. The class's interests have been safeguarded. That's exactly what happened here. The only person here who's trying to harm the class members is obviously Leland by trying to decertify this class. I'm happy to talk about the English case. We addressed that in our brief. English is obviously, I think, a very different animal. In that situation, things did happen before notice was given that made a big difference. Those people couldn't opt out because the road was relocated to a certain position. I don't have anything additional to say about that English case, but I'm happy to address it. Moving on very quickly to the final arguments about plaintiff being an adequate class representative. Again, my client has done nothing but adequately represent the class. There was no unjustified delay here. Finally, Leland has made this argument that my client no longer has a personal interest in this case after their shenanigans trying to get an ex parte order in his favor. My client still has an interest. His damages still have not been set. And even the amount that they tried to put in their ill-begotten judgment wasn't even enough. It didn't include all of the interest that my client had asked for, nor did it include attorney's fees. Finally, again, even if everything in this case, to my mind, went haywire in a way that I see hard to foresee, the court should reject the pickoff attempt, which is what this case is about. I mean, this entire appeal is about Leland trying to prevent having to pay money through a very creative argument, or the court should allow intervention by a new class representative. I don't want to waste anyone's time. I am more than happy to address any questions that the court may have, but if there are none, I will simply sit down. Thank you.
Thank you, counsel. Rebuttal. Counsel, you may be on mute.
Sorry about that. Thank you, Mr. Chief Justice. I'll be as brief as I can. First of all, for the record, Leland does not agree on the standard of review, at least as it pertains to the due process interests of the absent class members. That's a matter of law. That's reviewed de novo. The second thing, going to the long argument about the consent order, I just want to be clear, that is not a trial court's order exercising its discretion as to the proper sequencing of motions. That is an administrative order continuing a trial date, and it cannot bear the weight that is being placed on it in this case. Second, we heard about a lot of cases. As we explained in our reply brief, none of the cases, or virtually none, stand for the proposition that they're offered for. We explain why in our brief at great length. It's true, they don't stand for those propositions. They're being overstated. And in fact, the question of whether this can be waived, the Second Circuit in Philip Morris Inc. v. National Asbestos Worker Medical Fund says, although it does not foreclose the possibility of post-trial certification, it is difficult to imagine cases in which it is appropriate to defer class certification until after a decision on the merits. Difficult to imagine a situation. The Eighth Circuit in Paxton, it is rarely appropriate for a court to delay the certification decision until after trial on the merits. Fourth Circuit in Stachny versus Southern Bell Telephone, where a trial on the merits revealed the impropriety of class action maintenance, decertification of the class was the result dictated by both Rule 23's contemplation that the ultimate class determination, up or down, must necessarily precede any final decision on the merits, and underlying this by due process concerns for the putative class members. We also cite to First Circuit and Ninth Circuit cases expressing skepticism that this is ever appropriate, advising extreme caution to plaintiffs choosing to proceed this route, and because of the serious questions raised. We explained in our brief the harm to the absent class members. I won't belabor that, but the procedural harm is a harm in and of itself. The U.S. Supreme Court held that back in the 1950s. That's a harm. Mullane versus Central Hanover Bank. And there's the claim splitting issue and the concern. We don't know what we don't know. We don't know what those absent class members would have said had they been properly given notice. Perhaps they would have moved to intervene. Perhaps they would have said, hey, there's another fee that should be included in this case. And I'm worried about the preclusive effect of judgment in this case against my ability to bring that case later. But we'll never know because they weren't given that notice. And then finally, English is not different than this case. English is directly on point. And the rule that is being advanced by the plaintiff is twofold. One is virtually every plaintiff in North Carolina is now going to push to have the merits resolved before class certification. And now it is defendant's job to police that. And so virtually every plaintiff is going to disregard absent class members' due process rights and try to push for an early merits decision that runs directly contrary to the requirement that notice be given as soon as possible in the litigation. And I'll yield the remainder of my time. Thank you very much, Your Honor.
Thank you. Thank you to both counsel. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.